I certainly have said, and I think the team at Ripple has said for years, the industry lacks clarity and lacks certainty. The overwhelming majority of people working in the crypto industry, I think, are good actors that want to do right by regulators. But when the rules of the road aren't clear, it's very difficult to manage within that. And so for entrepreneurs and investors to participate in these markets, to invest in companies in this space, you want that clarity and certainty.
Hello guys, and welcome to my channel. I know most of you might have been paying attention, but for those of you who haven't been paying attention, some important news about Ripple's prolonged lawsuit with the SEC just came out. In December, in a move that stunned the crypto and blockchain world, the Securities and Exchange Commission sued Ripple, its founder and executive chairman Chris Larsen, and CEO Brad Garlinghouse, accusing the company of raising $1.3 billion in unregistered digital asset securities. The crux of the SEC complaint is that XRP is not a currency but a security, and therefore subject to strict securities laws. The lawsuit rocked Ripple. The SEC lawsuit in December 2020 was painful because it stunted what could have been XRP's bullish growth heading into the new year. Panic gripped investors, although the crypto remained resilient throughout 2021 before closing at $0.849 at year-end. The value of XRP dropped dramatically. Coinbase, a major crypto exchange, suspended trading in XRP. Instead of meeting with the SEC's requests, Garlinghouse announced that they would defend themselves in the XRP court action. Coinbase announced the delisting of the XRP token on December 28, 2020. Larsen and Garlinghouse wrote letters to the U.S. District Court, Southern District of New York Magistrate on March 3, 2021, stating that the SEC did not give fair notice. On March 8, 2021, the SEC requested an urgent hearing before the judge. Judge Netburn informed the SEC on March 22, 2021, that the Ripple XRP token has currency value and utility, distinguishing it from BTC and ETH. Hester M. Pierce, SEC Commissioner, published the Token Safe Harbor Proposal 2.0 on April 13, 2021, to provide a 3-year grace period for developers to understand their participation in decentralized networks concerning exemption from securities law. The court extended the SEC's deadline for releasing its internal crypto trading policies to August 31, 2021 from June 14, 2021. In 2021, the SEC revealed its internal crypto trading policies. The expert discovery deadline of October 15th was given for gathering opinions from crypto and security experts. On January 24, 2022, Netburn granted the SEC until February 17th to appeal her earlier ruling demanding that defendant Ripple Labs turn over certain sensitive government documents in the SEC's complaint, alleging that the XRP coin is unregistered security. The long-standing issue has seen the SEC taking several different positions over the course of the litigation, including claims of deliberative process privilege and attorney-client privilege, as well as Hinman's personal opinion versus public guidance, which we'll get to shortly. As we approach the middle of 2022, the SEC's lawsuit against Ripple is still dragging on, and it seems that privilege is still very much the theme of the season. Now the SEC has filed another document to support its earlier argument in favor of shielding internal SEC documents which are related to the 2018 speech delivered by the SEC's former Director of the Division of Corporate Finance, William Hinman. According to a filing dated 18th of May 2022, the SEC claimed the speech was developed by Hinman as an SEC official and not Hinman as a private individual. Additionally, Hinman had consulted with attorneys in order to develop the said speech, and the SEC wanted attorney-client privilege to protect speech drafts and other documents related to the speech. A filing provided by former federal prosecutor James K. Fillon stated the attorney-client privilege protects the speech drafts reflecting legal advice that Director Hinman sought and that attorneys in CorpFin and other offices provided, as well as portions of final drafts and emails transmitting legal advice regarding the content of the speech. But didn't the court previously rule that the speech contained Hinman's personal views? The SEC filing said, even if it contains personal views, Director Hinman did not give the speech in his personal capacity. The speech would bear no relevance to defendants' defenses if it had not been given by a senior SEC employee. The plaintiffs' back and forths on the matter have caused irritation among those awaiting awaiting an end to the XRP lawsuit for a number of reasons, such as regulatory clarity and the relisting of XRP, one of the most traded digital assets in the world. In mid-May, the Ripple Council responded to the attorney-client privilege claims made by the SEC and pointed to 4 reasons why the claim was without merit, in a brief that was deemed by XRP community pundit Jeremy Hogan as shoving down their throats pretty hard. Ripple's general counsel said, "What we've said since day one is that Ripple is defending this lawsuit not only on its own behalf, but on behalf of all of the entire crypto industry." In May 2022, the legal brawl centers on the emails of former SEC Director William Hinman. Hinman said in 2018 that the Ether cryptocurrency was not a security. Somehow, crypto analysts took it to mean that Hinman's statement was an endorsement that cryptocurrencies are not securities. However, the SEC refused to release Hinman's speech drafts and related emails despite the federal judge's order. The SEC sent a letter to the judge stating that the communications have attorney-client privilege protection. It argued the question of whether offers and sales of Ether constitute securities transactions is indisputably a legal question. Ripple wants access to said emails and related documents as it'll tip the case in their favor. It now appears that this is potentially a finite breakthrough that'll possibly put an end to this protracted lawsuit. In William Hinman's emails, Ripple might have found what will give them the final win. With the SEC refusing to produce William Hinman's emails, new documents shared by Empower Oversight show that the former SEC director violated the Securities and Exchange Commission's rules. The documents, which feature messages from Hinman's email, suggest how the former SEC director violated the agency's rule multiple times. In some of the conversations, Hinman was specifically warned by Shira Menton, the former SEC's ethics counsel, not to meet with Simpson, Thacher and Bartlett, a New York-based international law firm, while he was still working with the SEC. You have a bar under the criminal financial conflict with Simpson because you have an ongoing financial interest in the firm. Meeting with them while having such a conflict is not permitted. Excerpt of a message sent by Minton to Hinman. However, Hinman neglected all warnings and went ahead to have the meeting with Simpson Thacher on 4 different occasions, as he disclosed in another conversation he had with one of the staff using a private email address. On numerous occasions, Hinman's name has been mentioned in the lawsuit slammed by the security agency on Ripple. Hinman is now considered an integral part of the lawsuit because of his 2018 comments on whether Ethereum is a security, which was drafted in an email. Many believe XRP was also included in the conversation. Uncomfortable with Judge Netburn's ruling that they should make available a few notes, including a draft speech delivered by Hinman on June 14, 2018, the SEC filed a counter-motion asking the court to reconsider, as the agency argued that Hinman's draft is only a personal opinion and not public guidance. However, all efforts to have the SEC surrender the email have been futile, as the agency argues that some of the details of Hinman's comments are personal deliberations, which makes it protected by the Deliberative Process Privilege, or DPP. However, it is expected that the reluctance on the part of the court would soon be over, and Ripple can return to functioning as effectively as it was before the unfortunate lawsuit with SEC came about. It is a tad ambiguous, but for those who've been looking for a catalyst to jump on with XRP, this news certainly seems like what they should be paying very close attention to. Once the lawsuit is dropped, and evidence suggests that the ruling will be in favor of Ripple, XRP will have nothing holding it back, and the currency will soar amongst others. The clear indicator is that even though there are restricting conditions surrounding Ripple now, XRP has still managed to stay relevant. Imagine what would happen once this lawsuit comes to an end. That's all for today, guys. Kindly like and leave a comment in the comment section if you have any questions. Turn on the notification bell for quick updates such as